Developers Mario Hoffman of Kinay.f4v and Dr. Kinay of the Dallas Key Project were unsuccessful in their attempts to clear their names in the Commission of Inquiry's final report and claimed that the Commission of Inquiry published adverse statements against them. News 4 has obtained the written verdict in the case and can reveal tonight why the judges of the Court of Appeal turned down their application. The Court of Appeal judges, namely Edward Zaka, QC, and Justices of Appeal Elliot Motley, QC, and Richard Ground, QC, wrote that in relation to Hoffman, they thought that the learned Chief Justice Gordon Ward was wrong to find that there had been breaches of natural justice and the Commission's own procedure in the initial stage, but that he was right to conclude that in any event, the overall proceedings, when looked at in the round, were fair. Quote, "Turning to the detail of that, we think that the press statement of 15 July did not amount to a promise that the Commission would contact everyone whom it thought might be implicated. It described the evidence-gathering process that the Commission proposed. That was, after all, primarily an inquiry. What the published procedure envisaged was that if the Commission pursued someone who might be implicated for information or documents, it would, as part of that, tell that person the gist of the information against them. Nor did it promise an oral hearing to all such persons. It set out the procedure that it would follow in respect of persons whom the Commissioner wished to see. As the press statement of 15 July said, the Commissioner would invite those persons whom I may wish to see or to give evidence to give information orally. We do not think, therefore, even if Mr. Hoffman was a person of interest to the Commission at any early stage, that he was necessarily entitled to be told that or offered an oral hearing," the judge wrote. With respect to Dr. Kinay, the judges noted that, like Mr. Hoffman, Dr. Kinay was not summoned to give evidence during the oral stages of the Commission's proceedings or notified in advance of any interest that the Commission may have had in him. Unlike Mr. Hoffman, they said he was never invited to give oral evidence or indeed to put in written evidence. The Court of Appeal judges said it is not enough for Dr. Kinay to argue that some other procedure would have been better or more fair. They said he must show that the procedure in fact adopted is actually unfair. In our judgment, when viewed in the round, Dr. Kinay was treated fairly and in fact had an adequate chance to respond and put his case. We consider that, to the extent that he concluded otherwise, the learned Chief Justice was wrong. We also consider that the Commission in fact followed its own procedure in respect of Dr. Kinay, and there was therefore no breach of legitimate expectation in that regard. We therefore allowed the Commissioner's appeal and set aside the Chief Justice's declarations that his conduct was unlawful and dismissed the application for judicial review. For WIV4 News, I'm Takara Bain.